Hello, everyone. My name is Kelly Munn, and I'm with the League of Education Voters. Welcome to our free online webinar series, Lunchtime LEVinars. We started this series over 4 years ago to share information and build knowledge on important and timely issues. Last month, the Washington Supreme Court issued its latest order in the McCleary public education funding case, addressing whether the state has finally met its responsibility to fully fund basic education. In a unanimous opinion, the Supreme Court ruled that the state's plan to fully fund basic education will provide enough resources to meet its constitutional responsibility. But the court also ruled that the legislature's timeline for achieving full funding takes too long. In our free webinar today, former Washington Attorney General Rob McKenna, now co-chair of the Orrick Law Firm's Public Policy Group, is going to provide more information about the latest McCleary ruling and answer your questions. But first, a little background. Rob McKenna is an Eagle Scout, was student body president of the University of Washington, and attended University of Chicago for his law degree. He was elected for several terms to the King County Council, and as previously mentioned, served as the Attorney General for the state of Washington. He had 3 cases go to the federal Supreme Court, and he won every case. Rob McKenna also has a strong education background. He served for 9 years on the board of the Bellevue Schools Foundation, including 2 years as its president. He served for 10 years on the board of Bellevue College Foundation, including a year as board president, and currently serves as chairman of the board of the Data Quality Campaign, a national education reform collaborative which partners with the Education Trust. Before I introduce Rob, I'd like to go over a few housekeeping things. You'll notice a chat function on the right side of your screen. This is a space for you to pose questions to us. As always, feel free to send any feedback about the webinar quality to us on either the chat function or at info, I-N-F-O, @educationvoters.org. And with that, I'd like to welcome Rob McKenna.
Thank you very much, Kelly. And Eric, thank you for this opportunity as well. Welcome to everyone who's participating in the webinar. A little more background probably would be a good place for me to start about the principles at issue in this case. Then I'll provide an overview of the Supreme Court's most recent ruling issued just last month. Then we'll go through the Supreme Court's latest order in a little more detail to explain their reasoning. And finally, we'll take your questions. So my presentation will last about 15 minutes, and then we should have plenty of time for Q&A before the top of the hour. I find it kind of personally fascinating that I've been involved with the McCleary case since its inception. Since when I moved to Bellevue, Washington, back in 1977, I was a sophomore in high school. And that was right around the time that the Supreme Court issued its ruling in the last case like McCleary, the case that came out of the Seattle School District. Sometimes that's referred to as the Duran decision because the Superior Court judge who issued the initial ruling upheld by the Supreme Court was Judge Duran. And in that case, back in the 70s, the Supreme Court found that the state of Washington was not fulfilling its constitutional duty, its paramount duty under the Constitution, to amply fund basic education for all of Washington State's public school students. So there's a little bit of a back to the future feeling in the McCleary case, since that is at the heart of the current Supreme Court's original ruling in McCleary and in the rulings it has issued enforcing its McCleary ruling ever since then. The court has again found, as it did back in the 1970s, that the state is not meeting its paramount duty. And it's not doing that this time for some very specific reasons having to do with the legislature's decision to expand basic education and to accomplish goals like reducing class size, which they did not accomplish in a hurry after those new goals were adopted. back in the 1970s, there was a similar problem to today in that the state was putting more and more of the burden for funding public education on local school districts. Now, if you moved to the Bellevue School District like I did when I was a kid, that was a relatively good thing because we had a lot of money and we had a first-class education. It's why my parents chose to move to Bellevue. Of all the places they could have settled in Washington State when my dad retired from the military, they chose Bellevue because they had great schools that were very well funded to a significant extent by local voters. That, however, is exactly the kind of system that our Constitution's framers were trying to avoid. Our Constitution's framers wanted to make sure that the quality of a public school student's education would not depend on the zip code where they lived. They wanted to make sure that the state provided for basic education and that we would not rely on local school districts, local school levies, local voters to provide that education. By the 1970s, that was clearly not the case. There was a great deal of reliance on local levies. That was corrected as a result of the Seattle School District decision in the late 70s. But since then, the state has slowly but steadily shifted responsibility for funding basic education back on local school districts. In HB 2261, the legislature expanded the concept of basic education, which was within its power to do, and set goals for itself back in 2009. Then it not only failed to fund those goals, such as reduced class size for kindergarten to third grade, but it continued to shift more of the responsibility for funding basic education onto local school districts, so that many school districts have been spending raising nearly 30% of the costs of basic education from local resources. For example, a high percentage of local school district dollars, levy dollars, have been going to pay teacher salaries and other salaries in the district. But salaries like salaries for teachers are a component of basic education, and so that has to be funded by the state. So with that background in mind, in this sort of back to the future idea, let's talk about what the Supreme Court was addressing in its latest McCleary ruling. The court's decision, its order, starts out with a brief recap of the McCleary litigation itself. It starts by describing the progress the state has actually made over the last several years, stating that over the past several years, the state has made significant progress in fully funding the program of basic education, including by amply funding most of its components. It acknowledges that the 2017 legislature enacted a funding system that, when fully implemented, will achieve constitutional compliance according to the benchmarks that the court has laid out. But there's one component of that full funding that will not meet the established deadline of September 1, 2018. That's a deadline established by the Supreme Court for the legislature to fully fund all aspects of basic education. I'll talk in a minute about what component the court believes it is not fully funding by the deadline that it established of September 1, 2018. But it's important to note that the court did find in its unanimous ruling that the other major components of basic education, including the expanded forms of basic education, like voluntary all-day kindergarten, smaller class sizes for kindergarten through third grade, and other measures, are being fully funded or will be fully funded when the plan is implemented. The court concludes by ruling that until the state enacts measures to fully implement its program of basic education, not just have a plan to fully implement it, but to actually achieve implementation by September 1, 2018, so less than a year from now, quote, it remains out of compliance. So we're going to talk about what that means. What does it mean for the state, through the state legislature, to remain out of compliance? What are the consequences of that? When you go through the order that was issued by the Supreme Court last month, one of the first things you notice is how detailed it is. The court has put a lot of time into this case. It's invested a lot of its own resources, and I would say even its own reputation in this case, because it is rubbing up against the legislature's job when it tells the legislature that it hasn't done performed its constitutional duty. And the court is very sensitive about claims that it's trying to take over the public education system. It goes out of its way in this opinion to make clear that is not what it thinks it's doing. And so in order to make that case for itself and for its own role in this matter, it goes through for the first several dozen pages of its order, laying out the history of the case. It's worthwhile hitting a few of the highlights from that history that it lays out. First of all, I mentioned that the legislature passed a bill, ESHB 2261, back in 2009. That essentially set the legislature up for this court case. I think that a number of legislators who sponsored that legislation and voted for it knew very well that they probably weren't going to put the money behind it right away, inviting a challenge from school districts and other allies under the Constitution, which is exactly what happened. In 2012, the Supreme Court issued its first unanimous opinion, ruling that the state was not fulfilling its constitutional duty to amply fund public education, at least basic public education in our state. On January 9, 2014, it issued an order finding there had been a lack of demonstrated progress and directing the state to submit by April 30, 2014, quote, a complete plan for fully implementing its program of basic education for each school year, close quote. The state didn't submit its plan as ordered, and as a result, the court found the state in contempt and then held any sanctions in abeyance to allow the legislature to act and to adopt a plan during the 2015 legislative session. This tug of war between the court and the legislature over a plan to fully implement basic education funding is an important point because it really underscores the tension between the judicial branch and the legislative branch of our government. The legislature's position was it cannot bind a future legislature simply by adopting a plan, and therefore it has resisted adopting plans that would appear to be set in stone for future legislatures. It believes it can't constitutionally do that. The court, on the other hand, keeps insisting that the legislature must develop a plan and submit it to the court, which shows it fully implementing basic education funding by September 1, 2018. And so you have this tension, which going back over several orders and including the finding of contempt and then the sanctions for contempt, often boil down to this question of whether the legislature has to submit a plan for achieving compliance. Instead, the legislature has been adopting increased funding levels, and significant increased funding levels at that, bringing those funding levels back to demonstrate to the court it's making progress. The court still isn't satisfied because not every element will be fully funded by September 1, 2018, and it still hasn't seen the written plan that it's demanded from the legislature that shows how they'll get there by that deadline. So finding that the state was still in contempt after the 2016 legislative session, the court ordered and imposing a $100,000 a day fine in the meantime, which they finally did in the fall of 2015 after the 2015 legislative session. The state has continued to find that the legislature or the court has continued to find that the state is in contempt. And it directed the state to file within 30 days after the signing of the 2017-2019 biennial budget, a report summarizing the actions taken during this year's legislative session to implement the state's program of basic education. And it reminded the legislature that they have a deadline of September 1, 2018. So the state did submit its report after the 2017 legislative session, demonstrating what the legislature had accomplished during that session. And then the plaintiffs in this case filed their answer to it. On October 24th, the court heard oral arguments in the case, and in November of this year issued its ruling. So in reaching its conclusions about why the state was now in compliance with the McCleary order and how it wasn't, the court goes through a great deal of detail about the state budget and about how the state has actually stepped up and, in fact, in most cases, but not all, fulfilled the court's order by amply funding basic education. The court starts by reminding us that the reason behind its order in 2014 was the legislature's failure to make adequate progress towards the funding goals and implementation of the reforms that the legislature itself had adopted. This is an important point. The legislature was the body that expanded the definition of basic education, and by doing that, expanded, in a sense, its constitutional funding duties. And then it failed to actually meet those. The court has been unanimous all along in this case because it's saying, look, legislature, you have to do what you said you would do. You're the ones with the responsibility for defining basic education, and you haven't met the funding requirements for that expanded definition of basic education. The court noted in its earlier orders, as I mentioned, that the state, in its view, was not on track to achieve by 2018, for example, the K-3 class size reduction goals for the second and third grades in low-income schools, or for any K-3 classes in other schools. It went through in those years and detailed the ways in which the legislature wasn't doing its full job in coming up with the funding and a plan for the funding. And so in 2017, the legislature took a lot of steps. To their credit, as the court acknowledges in this opinion, the legislature significantly expanded funding for basic education across the state. I'll go into that in a bit more detail in a moment, but I also want to talk about another aspect of the McCleary ruling in addition to funding, and that's the question of where the funding comes from. It's important to understand that the McCleary ruling is not just about the level of funding for K-12 basic education in our state. It's also about who provides the funding. As I've already mentioned, one of the bases for the Duran decision back in the 70s was also a basis for the McCleary decision in 2012, and that was that the state had been steadily shifting more and more of the burden of the cost of basic education from the state budget over to local school district budgets, which then had to raise money through local levies, like local maintenance and operation levies. This year, in 2017, the legislature, through the bill that it adopted, EHB 2242, deals with local levies. For example, it renames the former maintenance and operations levies as enrichment levies. If any of you watching this have been a volunteer, as I have, for your local school district levies, you've worked to try to get the voters to reauthorize or even increase your M&O levies. Those are now called enrichment levies because the legislature has directed that school districts may use enrichment levies and transportation vehicle enrichment levies solely to enrich the statutory basic education program, which is supposed to be funded by the state, not by local school districts. It does that by, in part, by increasing the amount of money coming out of the state property tax levy and putting a limit on the amount that the state, that local school districts can raise from local levies. In fact, as the court points out, beginning with property taxes levied for collection in 2019, the maximum that may be levied by a district for enrichment, the maximum school district levy for enrichment is the lesser of $1.50 per $1,000 in assessed value. Keep in mind that a lot of school districts have much higher local levies than $1.50 per $1,000, or the maximum per pupil limit, which is $2,500 per pupil. So this session, the legislature took two big steps. It dramatically increased the amount of money being spent on local, on basic education, and it changed where that money is coming from. For example, by raising the state property tax levy over time to $2.70 per $1,000 from the 2017 rate of $1.89 per $1,000. So it is shifting that levy. Sometimes that's called the levy swap because money from local levies comes down, money from the state levies goes up. The court spends a great deal of its time in the remainder of its order laying out the ways in which the legislature has expanded funding in the current session. So let me just turn to that, assuming I can find the page that I tagged, to tell you just what the highlights of those spending increases are that the court found to be very important. The court points out that under the budget and the 4-year budget that the legislature had to adopt, per pupil spending will increase from $6,655 per pupil in 2010 to $12,202 by 2021. In other words, the amount of spending is going up by almost 100%, about 98%. The court also observed that K-3 expenditures although I think they actually meant K-12 expenditures, now I had to read this again, will make up just over 50% of the state budget in the new biennium compared to 43.5% in 2011-2013. And the share of the budget for K-12 is expected to increase to 53% of the total state budget by 2019 to 2021. So the court is clearly impressed by the fact that state funding for K-12 education is increased as a result of the 2017 legislative session from $13.4 billion in the 2011-13 biennium to $22 billion in the current biennium. And then it will go up to $26.6 billion in the 2019-2021 biennium, representing an increase between 2011-13 and 2019-21 of 98%, from $13.4 billion to $26.6 billion. So given all of that, why did the state Supreme Court decide to find the state was still in contempt and to leave the $100,000 penalty in place? The $100,000 penalty, by the way, is the penalty that the legislature the state has to pay. It goes into a segregated fund for basic education. So it rolls in and is actually counted as some of the money they'll be spending for basic education. There's a lot of debate over whether or not it's much of a penalty, since it's like taking the money out of one pocket, putting it into another pocket. But there it is, and it will remain in effect for the time being. Why? Because the court ruled, quote, that the program of basic education cannot be said to be fully implemented by, oops, sorry about that. That's showing up on your screen. I'll get rid of that. There we go. The program of basic education cannot be said to be fully implemented by September 1, 2018, when it puts off full funding of basic education salaries until the 2019-2020 school year. As things stand today, the salary allocation model enacted by the legislature complies with the state's obligation to fully fund basic education salaries for K-12, but it will not be fully implemented by September 1st, 2018, because the state admits they don't have enough money in the state. They haven't put enough money in the budget yet, even though there is enough money in the state's general fund to fully pay for the program if they want. This is about the point that we're supposed to be funding K-12 education with our first dollar, not our last dime. And the court is pointing that out. So where does this leave us? There's another legislative session that will still take place before September 1, 2018. When they convene in January, there will be pressure on the legislature to complete the full funding of the salary allocation model so that the state is indeed picking up the full cost of salaries for teachers and other staff in school districts. The state does have the money. The budget is projected to grow to over $44 billion in the general fund. And that means they'll have to spend less money on other things. But the court is pointing out in its opinion that they have the money, they need to spend the money, and they cannot defer fully funding salaries until 2019, 2021, which apparently is what they currently intend to do. So with that, I'm happy to answer any questions if we have some, and thanks for following me on this whirlwind journey through this 45-page order from the Supreme Court.
Thank you, Rob. We have about 10 minutes, five minutes, and we might go 5 minutes over if we have questions. Folks who are listening, please type your questions in the chat feature on the right-hand side of the screen. And I just want to remind you that really no question is too basic. I can guarantee you that if you think it's basic, there's at least 2 or 3 other people who want to know the answer. While I'm waiting for you to type in some questions, we've got a question here of our own. So Rob, if the legislature does not meet the September 1st deadline of fully funding education, what do you think the court will do? And what is the court able to do?
Well, that's the $100,000 question, I guess, the $100,000 a day question. No one really knows. I'm not sure the court knows. Individual justices at various times during oral arguments in these hearings to enforce McCleary have suggested that they might order that some, tax preferences be closed, that more revenue be generated. Some have suggested the court might order shifts in dollars from one part of the state general fund budget to the budget for K-12. We don't really know. I think the court has been wise in its restraint when it issues these orders in, making specific threats. They have to be wary of overstepping the boundaries that are appropriate for a court in a judiciary, in a system of government that has 3 co-equal branches. And I think they have been prudent, they have been careful. My guess is that one way or the other, the legislature will come up with the additional $1 billion in the next legislative session to finish the job of fully funding the salary allocation model they've adopted. I think that once they accomplish that in the 2018 legislative session, then they'll meet their deadline by their deadline of September 1, 2018. But to some extent, there's a little bit of a game of chicken going on here. I think you'll hear a lot of debate in the coming legislative session about whether or not taxes need to be increased. There'll be proposals for perhaps new taxes like a capital gains income tax that the proponents will say we must have in order to have enough money to meet the McCleary mandate. But, you know, as the Supreme Court points out in its own opinion, there's already more than enough money in the budget. If the state general fund budget is over $40 billion and the portion going to K-12 is currently $20 billion, then obviously there's more than enough, 20 times more than you need to move another $1 billion into it. The problem with that politically is that, you know, it causes pain to legislators and others who would rather not have to reduce spending in other areas by that $1 billion. So that's the pressure that they feel. The court did notice, or did give recognition to the fact that the legislature substantially increased revenues from the state going to K-12 by about $5 billion. And it's done that through the property tax increase, and it's also done that by closing some tax preferences, like eliminating, or I should say imposing the sales tax on bottled water. And there were a number of other examples the court has mentioned. But the court is very clear in its order to say it's not for us, the court, to decide which taxes are supposed to be increased, which tax loopholes should be closed. That's up to the legislature. We're just saying they have to do the job of fully funding the basic education by the deadline we, the court, have imposed.
Thank you, Rob. Let's see. You know what? I can do this question right here because this was on my list of questions. What about special education funding? Special education students receive basic ed allocations as well as safety net funding, but there's often still a gap that's left unfunded. School districts can't use local funds for these students as it would fall outside the definition of enrichment. How should this fill the gap?
Yeah, that's a problem, and there are other programs where people feel not enough money is being spent. In fact, the plaintiffs in this case argue that the proper measure of amply funding education is not whether or not the legislature is satisfying its own funding formulas and fully funding education under those funding formulas, but whether or not the legislature is, quote, covering the actual cost of education. The Supreme Court rejects that actual cost theory, pointing out that throughout the McCleary case, going back several orders, the court has found that so long as the legislature follows its own funding formulas, which the court concluded early on were adequate, that it's meeting its constitutional duty. That throws the question of the adequacy of funding for programs like special education back to the legislature to decide whether or not those amounts should be increased. It's unlikely that the Supreme Court will step in and order increased spending for specific areas of education like special education, because it's trying to leave the policy making to the legislature and to restrict its role, as it should, frankly, to interpreting the Constitution.
Thank you. Someone's asking if the recording will be online. It'll be posted within 24 hours and sometimes earlier than that.
By the way, if anyone would like to read the court's order, it's very accessible. I don't just mean that you can literally get access to it, but it's really easy to read. And it's a great primer on this whole set of issues. It's available at the Washington State Supreme Court website. If you just scroll through, they list their orders in chronological order, and you can look this one up online and read it online or print it out. They issued it on November 15th last month. So if you're interested, again, it's very well written, and it's an excellent framework for understanding all of these issues if you have the time to take a look at it.
Thank you. I think Rob, if you can go 5 more minutes, we'll go 5 more minutes.
Okay.
I'm going to wrap for those who have to leave. We did this a little differently this time. We're using video rather than just slides. We would love to have feedback from you, so feel free to write a message in the chat or send me, Kelly, at educationvoters.org, an email to tell me what you thought about that. Our next LEVinar will be Thursday, January 4th at 12:30 with LEV's own Policy and Government Affairs Director, Daniel Zavala, who's going to be doing a 2017 year in review and a legislative preview. I'm going to take, I'd like to see Marguerite's.
Sure. Yeah, you bet.
If the legislature shifted to a weighted student formula like California that specified a dollar amount per pupil and per pupil type, and then funded that dollar amount, would the court see the state as meeting its obligation?
Yeah, I think it would. Again, the court is, saying to the legislature, it's up to you to create the funding formulas as long as we find that they're adequate. But you're responsible, legislature, for the details, and then we're going to hold you accountable for actually implementing them. So I think if the legislature did move to that model and then actually funded it, then they probably would be fine with the Supreme Court.
Valerie Hughes has asked, why has the legislature failed to adopt a salary schedule for teachers and left it up to districts to do that?
I don't know.
Allegedly, won't that mean that districts will, with more senior staff, will be shortchanged?
First of all, hi to Val Hughes. When I was a young lawyer, I worked in the same office as her. She's a terrific attorney. Secondly, I don't know what the legislature's reasoning there was. I have to admit I have mostly focused on the legal issues in the case, and I have not paid as close attention as folks like Val have to the legislature's work on the details of the funding formulas and the salary allocation model. So I'm sorry I don't have an answer to that.
Thank you. Hello, Susan. Susan has asked, can you please repeat the per pupil funding figures in dollar amounts? Would the levy amount, the smaller amount of $150 per 1,000 or $2,500 per pupil?
I don't know if it's the lesser of or the greater of. Hang on, let me see if I can. I've got all my pages scattered here. Let me see if I can find that real quick, because it's in the section on levy reform. So I'll try to find that real quickly. Shoot, I might not be able to put my hands on it. Oh, no, I found the page talking about what the new state property tax levy will be. Oh, here it is. Yeah, it's the lesser of. I'm quoting now from the court's order. This is at page 11 of their order, if you happen to look it up later. Quote, beginning with property taxes levied for collection in 2019, the maximum that may be levied by a school district for enrichment, keeping in mind levies are limited to enrichment now, is, quote, the lesser of $1.50 per $1,000 of assessed value, or the maximum per pupil limit, meaning $2,500 multiplied by the number of average annual resident full-time equivalent students enrolled in the district the previous school year. So it's the lesser of $1.50 per $1,000 or $2,500 per pupil.
Thank you. This is going to be our last question, and it's coming from Dave Larson. What is the net increase in per student funding, given the fact that the new funding system will take away significant local funding while adding state funding?
I don't have the net figure because it's not in the Supreme Court's order. The Supreme Court focuses on total per pupil spending. which it says will increase from $6,655 in 2010 to $12,200 by 2021. Those are the only figures that the Supreme Court's order contains on a per pupil basis.
Thank you. Thank you to you, Rob, for joining us today, and thank you all of you who listened in. If you have any additional questions or comments, please send them to kelly@educationvoters.org. A recording of today's presentation will be available on our website, and please feel free to share it with your friends and colleagues. Again, we have a legislative preview and wrap up of the 2017 year on Thursday, January 4th at 12:30. Thank you all again for attending, and we hope you'll join us in the future.
Thank you.